Types of bond in Indiana. In Indiana, there's multiple forms of bond. The most common for lower level offenses without victims is going to be an OR. They're releasing in your own recognizance. You basically look the judge in the eye and you say, I promise I'll come to court. You're also promising you're not going to get charged any new crimes. You're going to do whatever the judge tells you. Now, some people are like, well, Mark, I never told a judge that. It's implied. If you get out and don't pay bond, you won't get arrested and you're going to come to court. It's called an OR bond. Those are the best because no money is paid to get out. The second most common type bond is a cash bond. $200 cash bond, $2,000 cash bond. You got to pay that entire amount to get out of jail. If it's a cash bond, you got to pay the whole thing. Defendant can pay it, family can pay it, anyone can pay it. But they are on the hook for that entire cash bond, and that cash bond can be used by the court later to pay for fines, fees, anything like that. And the person that paid it would get the leftover of whatever's back. So if you pay $2,000 for someone, doesn't mean you're going to get $2,000 at the end of the case. The next type of bond is a surety bond. Now, a surety bond would be like $100,000 surety. People start freaking out. I don't got $100,000 to put down. That's okay. You hire a bondsman. Typically, bondsman charges 10% of the bond. So $100,000, you pay the bondsman $10,000. You got some bondsmen doing 8%, 9%. It's a competitive market, apparently. But you pay the bondsman a percentage, and the bondsman puts up the money for you. And if you mess up, don't come to court, theoretically, the bondsman is liable. So courts like surety because theoretically, there's someone looking for you if you don't come to court. There's an interested party making sure you come to court. Now, the next type bond is some sort of mixture of cash and surety. You see this a lot with victim cases, or I don't know why judges choose this, to be honest, but they do. $10,000 surety and a $1,000 cash. People are like, how much money do I need to put up? Well, you got to pay a bondsman $1,000, 10% of that $10,000 surety. Then you got to pay the court $1,000 cash. So it end up being out of your pocket $2,000. The nice part about a cash portion is, though, it is available at the end of the case, at least to go towards fines and fees, and the person that paid that could get some back, theoretically. The next type bond is a personal recognizance bond. Basically, they want people in the community to pay your bond for you, $100,000 personal recognizance. Basically, your friends or family, mom, sister, best friend, puts up 10% of the $100,000, whether it's property, whether it's cash. But the idea is people in the community are encouraging you to come to court, so you're less likely to just run from justice if you know you're going to hurt your mom financially or your best friend from middle school. There can even be a mixture of cash and personal recognizance. There can be a mixture of personal recognizance and surety. The possibilities are endless. Ideally, though, if you don't have any history, you're going to get OR'd, meaning just promise to come to court. If you have any questions about bond, bail, or anything like that, give us a call, 317-632-3642. We love talking criminal defense. In fact, we'll talk about it all day. Most importantly, though, and this is the best advice you're ever going to hear, always plead the fifth.